Hello there. Thanks for joining me. I am Dr. Jen, and this is my life as a landlord. I am so excited for you educating yourself in your landlord journey by listening to this podcast. I'm so pleased to have a great guest for you on today's show. She is an attorney out of Michigan, outside Detroit, and has been around real estate for a long time. Her specialty is among other dirt related things, she's helping landlords like you and me stay out of litigation, which is pretty vital. She's going to hit on several pain points today, including working with contractors and using your title insurance, among other tools as a property owner. Here to tell us about this experience and more, welcome Corinne Rockoff. Hi, Corinne.
Hello. I have to get new business cards that say dirt attorney and other things now. That's my favorite thing.
That works for me, dirt attorney. You know what? It's so funny, little branding things like that. It works. People remember that stuff. That's cool.
It's
Oh
accurate
my
and it's
goodness.
fun.
That's awesome. Well, so you're in Michigan, you're outside Detroit, practicing law, but you didn't start there. You were started in California somewhere.
That is right. I'm a little bit of a migratory bird up until a while back. I'm now firmly planted in Michigan, but I have spanned the whole US. I grew up in Southern California, spent time in Pittsburgh, in Washington, D.C., and I have now firmly landed and planted my roots in the dirt in Michigan.
Awesome. Awesome. So, and how did you end up in dirt real estate stuff?
It's funny. It wouldn't have been on my to-do list because, in all honesty, the property law classes they offered in law school, I say this with so much love and appreciation towards those professors, not my favorite classes. A lot of it is very antiquated and, old-timey deeds and all that kind of jazz, and it did not speak to me. However, I did my undergraduate work at a school with a lot of engineers, and a lot of my friends were engineers, and it turns out I developed this accidental fluency in engineer speak, and that has kind of led me towards construction and some of the related topics. And construction happens on dirt, and there's a lot of moving parts and pieces. A lot of it links back to finance, and when you put all those things together, you end up in property law, and it is a lot more fun in real life than it ever was in school.
Well, I speak engineer too, only because I was an engineer. I'm super happy that I can talk about that. And shifting into dirt work, contractor stuff. You and I talked, and there is a lot of commonalities between Michigan and Hawaii when it comes to contractors and licensing with contractors. What are some of the issues you see when a landlord or a property owner hires a contractor? In Michigan, and some of that is expanding to other places in North America, not just in the States, but also in Canada. But tell us what you see.
Well, and before I jump into the full
Oh,
answer
yes.
there, I have to give my formal official attorney-ish disclaimer that while I am always happy to chat with new folks, what you are hearing right now, because I am a lawyer, but I'm not your lawyer if you're listening right now, unless you're my client, hi. But unless you've specifically retained me, I am not here to offer legal advice to you. I'm speaking generally. We're just chatting. If you do want legal advice, give me a call. We can form that relationship, but we haven't yet. So all that aside, no legal advice to follow, but I can tell you about some of the things that tend to crop up for a lot of folks that I do work with. So one thing that I know tends to pop up and bite people is you meet a wonderful person, you chat with them, they tell you all about how they're a contractor, they've maybe have 40 years of experience in the industry, but they're not actually licensed. In a lot of contexts, that can limit your ability to recover in certain ways if something goes south. And if you've ever hired a contractor, it's a non-zero chance that something is going to get a little funky along the way. So that's a first thing that I always tell folks to keep an eye on, is whether or not your contractor is actually licensed.
And it's interesting because I'm sitting here going, what about in jurisdictions like Texas where contractors don't have to be licensed? And so it's not just Michigan or Hawaii. You've got to
Right.
really know your local area of what are the requirements. And this is exactly why you need to have legal representation in your local area, whether you're in Alberta, Canada, or California, whatever it might be. But it's interesting knowing that my listeners have spoken loud and clear that one of the biggest pain points in their world as landlords is tenant screening, but right
Mhm.
behind it is contractor screening. How can
And
owners
yeah.
and landlords protect themselves when they are screening contractors, licensed or not, however, whatever location they're at. How do they protect themselves?
There's so before we even that, I will also say right now, just because we're in the southern US in the middle of, peak of hurricane season, it's causing contractor migration, which top two things that migrate: geese, contractors. Just they move around all the time
I've never
where
heard that
needs call them.
before.
It's true. And you see a flood of people. I mean, it's really something. You can see people move kind of on a cyclical basis throughout the country. Folks flood into some areas after there's been a big storm up north for roof damage. Like there's always people moving around. And also keeping in mind with that, it's not just, even if you've got a Texas contractor who doesn't have to be licensed when they're at home, but they're shipping off to temporarily work in a state that does require licensure because we've got all this motion. Just keep in mind anyone who's in an area that is significantly impacted by some of the severe weather we're seeing this time of year. If they tell you, hey, I'm from Texas, I don't have to be licensed. If they need to be licensed in your state, that's still going to be a factor. Keep an eye on that and talk to counsel in your area. But yeah, as we're in the midst of 'tis the season for that sort of thing. But beyond that, beyond just doing that basic check of, hey, am I working with somebody who's licensed? Communicate with your community about what kind of work has that person done before. And I don't just mean talk to your neighbor. You can take a look online. For example, if you know they've done other projects in your area, they're established in your area, check and see, does the county that you happen to be in or your province, wherever you are, can you do a litigation search to see if that contractor has been sued? I've had situations, and this is right in the front of my mind because it's since you and I last talked, Jenna, this has actually come up. Somebody who had been sued in another state, and therefore my client who had hired this contractor actually got a notice in the mail that another former dissatisfied customer had won their lawsuit against that contractor, and they had successfully, under the other state's laws, liened the proceeds of that job. So instead of paying his contractor for the work being performed, he was being directed to pay this other former dissatisfied customer. Whole other can of worms. And
Wow.
because it was an out-of-state lawsuit, it would have been tough to look up unless you're searching every jurisdiction. But whatever reputational research you can do, including checking dockets, take a look, see what the news is out there in public records, not just on Yelp.
Yeah.
Always going to be an asset.
Wow. Well, and there are other means that you can search contractor complaints. I know there is
Absolutely.
a spreadsheet or search engine in Hawaii, the state of Hawaii, where you can search complaints, and it's not just in the state of Hawaii. There are other public forums. Some of them you might have to pay for, and then some of them you don't. So it just depends. Yeah. Well, let's go down that rabbit hole of, let's say a landlord has some kind of an insurance loss. They have a flood, a leaky toilet, whatever leaks through, it's a cascading flood, something happens, and they hire a contractor with or without an agreement. We can do both if you want, but at some point the contractor fails to perform. At some point something goes sideways, as you had said. I love it. It's non-zero chance that something is going to go wrong. There will always be something that pivots away from the original scope of work. And so then this, landlord or the owner has to do something, whether you have a lawsuit and they sue the contractor or they sue the company, or, how much effort is it worth? Because again, this whole time, this contractor's failed to perform, this unit is not rentable unless you've paid another contractor to fix it. And so let's go down this rabbit hole of how much is all this worth, not just in money and time, but in mental health for the landlord in trying to collect.
Yeah, there is so much calculus to be done. And I have this conversation with a lot of folks, some of whom turn out to be clients, some of whom don't, because I sometimes have to start these conversations by saying, I'm here to disappoint you, because you have to think about, unfortunately, the way that it works, when you are having a, civilian to civilian dispute, there is not an appointed attorney who materializes with a magic wand out of the sky. You do have to act. Yes, I want a ding sound effect
Ding!
for right
There's
here.
your
And
magic wand.
if I could be the magic wand attorney who just got to appear and bless everyone with legal pixie dust, I would love to do that. But sadly, not a job that I have been able to identify as available. So you have to think about not just, okay, you're going to have the cost of retaining counsel, you're going to have the time investment, you're going to have filing fees, you're going to have just the headaches and the mental energy. Um, but I do think that's why my strong preference is to engage in the business of litigation prevention where we can, and focus on having a relationship. So you want to, like we're talking about, doing your research on a contractor in advance before you engage them, and also making sure that you're communicating with them actively throughout the job so that you're building and maintaining that relationship. And that way, if you're communicating, and also my personal preference is that you're communicating in writing, including an email. An email is a writing. I love it because it's also time stamped and dated. And you can even turn on those little read receipts. It's great. That can be very handy in hindsight, but you can communicate in a productive, friendly way. And a lot of the time that can help steer people out of litigation land and resolve something so that you don't have to go down that route and put yourself through the anguish.
My
So that's
goodness.
always my preference. You can litigate. I have fun when we litigate, just, the parties involved usually don't.
Well, let's go down that let's say, an owner or landlord does do the lawsuit and
Mhm.
let's say they win. Let's say they win a judgment and, then you have to actually collect on that
Absolutely.
judgment. And, I know it's different in Michigan, it's different in California, it's different in Manitoba, it's different in all over these places. But what are some of the things that people can do or not do to actually get their money? Or some of the stuff you've seen loopholes that people can
Oh,
escape
absolutely.
the judgment?
So just because, so if you make it all the way to the end of that process and you've given yourself 3 migraines and, a legal bill and you need a nap, and you get to the end and you go to trial and you end up with your judgment, and it is a court order that says, you contractor, thou shalt pay me X dollars. That paper is still just a piece of paper. So you have to actually turn that judgment into money. And that process is called collections. So, and you'll hear about collections companies that, will pay pennies on the dollar for it and keep the vast majority of the proceeds to do that for you. It's always an option, but you're going to get a very low percentage of what your actual dollar amount on the judgment was. Um, a lot of contractors, though, have a lot of portability. And I'll use Michigan as an example just because I'm sitting here. But in Michigan, contractor licenses are portable because they are tied to the individual as opposed to the business entity. So if I'm John Smith, the contractor, and I have been operating John Smith's contracting for 10 years, I get sued. There's a judgment against the company because John Smith's contracting LLC signed the agreement with you, the landlord. Um, I get that judgment and I look at it and I say, well, golly gee, I can be John Smith at any company, and I open up John Smith's contracting number 2 and I stop operating, and all of my new work going forward, I'm entering into my new contracts as John Smith contracting number 2. First, John Smith contracting doesn't have assets anymore, right? And there are some measures that you can take if you're working with an experienced collections attorney to kind of pursue that. And it's called piercing the corporate veil, but it's a whole process and it's really tough. And I've had a lot of conversations with folks where the cost of attempting to pierce the corporate veil and get to whatever assets they might be hiding is going to be 5-10 times the judgment amount in smaller cases. And you're going to end up with a really pretty piece of paper on your wall and a big legal bill. And some collections costs are recoverable, some aren't. It becomes really complicated really quick. So thinking about not just how much money do you think that you are owed and you deserve in your heart of hearts, and maybe the court even would award you, but doing that calculus with the legal fees, the time, the energy too, it's tough. It's a hard piece of math to do for people.
Yeah, the grief to dollars ratio really has
Yeah.
to pencil out. And if it doesn't going in, sometimes you just sleep better at night going, you know what, I have this terrible loss. Silly me, I hired a contractor I shouldn't have, and let's just move on. Because at the end of the day, the goal of hiring that contractor in the first place was to get back a rentable unit
Yep.
that you can have a paying customer, paying tenant in. And the sooner you get to that, the better. And so sometimes it's just better to just go, you know what, you know, just leave it. There's so much on social media about people going, hey, how do I get my money back from this contractor that I paid in full upfront? And I'm going, Oh my gosh, why would you do that? Why would you,
Yeah. First
right?
piece of not legal advice, but just advice from my heart as a human being, don't do that. And I say that to you, even as it is really hard to manage some of these situations, especially when we're talking about how tough it could be to find a qualified contractor
Yeah,
right now, to get materials, to get
right.
labor, all of this stuff. I will tell you, just on a personal level, I was in a situation just to my own home trying to get a kitchen remodeled because, and this was, I think 2021. So we were in an even tighter
Mm.
spot, labor and materials wise, um, because of the options available on the market. I ended up moving forward with a contract I wasn't super happy with, and I got ghosted by a contractor personally. Now, I will say this. One thing I did not do, I did not give any money up front. I did purchase my own materials, but I had them in my possession. So
Mhm.
anytime that you're uncertain, you can take these little measures. So I did end up having to store a significant amount of flooring in my basement until I could get a replacement contractor to actually install the stuff. However, the grief ratio was still pretty high. It was a very aggravating situation, but the grief to dollars calculus still turned out pretty good because I wasn't out dollars, right? So the less confidence and trust and reputational backup you have in somebody new that you're bringing in to be part of your business, like a contractor, make sure that the less you know about them, the harder you should be looking at your contract. Now, I prefer that everyone look at it really, really hard every time, but I know that's not always possible. So when it's somebody new, think about what extra protections you would want to have if things go wrong. Be kind to your future self, just in case.
Wow. Good advice. I love it. Well, there's another pain point that you and I were talking about, and I have to laugh because when we're talking about landlords who are listening to this podcast, regardless of the location, there is one common thing. They all had to purchase property at some place, sometime. And when they closed, there is a little tool that many people don't realize how powerful this tool is, and that is title insurance. And you
Which
told me a
people fall
story.
asleep when they hear those words.
I know most people do, but it's such a powerful tool that I don't think people realize the power of this title insurance. Tell us a story that tell us your story about Party Island if you would, and just let us know about this, because this, and I want you all to notice as you talk, as she's talking about this, the length of time, not of the story, of the entire process. There you go.
Okay. So I will take us all in a little journey to a place that I call Party Island. This is a case that did actually come through my office. It's a matter of public record, so I can talk about it. And it is a matter of public silliness. And I say that not because it was fun or silly for the people who were actually involved, but now that it's done, I can tell you that it is rather silly. All right, picture in your mind's eye, if you would, a beautiful placid lake in the center of which there's a little island. Surrounding the lake are a number of folks who are owner-occupied properties. A lot of them are, folks who are very excited to spend time at this lake with their grandkids, all of whom have homes that back up to the water. And in the center of the island, in the center of the lake, on the lovely little island, is what I can only describe as a party mansion. It was built to be rented out as an Airbnb. It's not too far from a large university. And so it is the ultimate spring break destination in the area. And it is thoroughly booked and busy and is operating as a short-term rental. Neighbors on the outside, whose properties all back up to the lake, um, don't love having a Hardy Mansion as their lakeside neighbor. There are, beer bottles floating in the lake all of a sudden, whooping and hollering at 2 a.m, etc. They are displeased, and so they band together and file a lawsuit alleging that the presence of this home is a nuisance. That's not the part where I get involved, despite the fact that that's where the lawsuit begins. There's a character who is a very enthusiastically litigious fellow who is the owner of Party Island. We go through the first couple of years of litigation, and it starts out with all of the homeowners on what I'll call the mainland gathering together to sue the owner of Party Island for causing a ruckus, essentially, but in a more fancy legal way. However, Mr. Party Island responds with an enthusiastic countersuit. where he gets really creative. He gets a couple of real free-thinking lawyers who come up with this legal theory that essentially, because of the way that the deeds that gave Mr. Party Island title to the island, because of how all of those are phrased and structured, his parcel of property actually includes all of the lake bottom that surrounds Party Island. And he has a legal theory that because at the time, back in, I believe it was the late, I want to say late 1700s, it was far enough back that when I'm looking at these documents, all of the S's are written like F's. That's the era that we're talking about. It's very hard to read. But because of how that document was phrased and structured, and because of how the property lines were described, his assertion is that he owns all of the land to the edge of the lake where it touches the land on the mainland, but where it touched the land on the mainland at the time that that deed was signed more than 100 years ago. And it is also his assertion that the water level has fallen since then. So the lake has shrunk, which means that in his mind, there is a strip of sand on this little beach, a couple feet wide, in a ring that separates all of the mainland homeowners from the water. And in Michigan, if your property is not touching the water, you do not have access to the lake. So all of these folks who were delighted by their lakefront property suddenly have property that is 2 feet from being lakefront, and they have boats that are in water they cannot legally access. That is his claim. Headache and a half. They all had private counsel already, because remember, they're the ones who started this lawsuit, right? So they had their own attorneys. However, they're trying to defend against this counterclaim. It's a mess. We're talking, I think there were 17 or 18 homeowners in total that are all these owner-occupied folks banding together on the one side. Somebody thinks to themselves, I'm so glad that somebody did, because one, if they hadn't, I wouldn't get to know this story or tell it to you, but two, because it was a smart thing to do. Hey, I have title insurance. And what title insurance functionally does is it says, whatever your deed says that you bought, that insurance company is insuring your interest in what your deed says you bought. So if it said, I bought from here to here, there to there, and somebody shows up and said, hey, actually, you have 6 inches less. Your back fence needs to scoot in 6 inches, right? That is a claim that could potentially be covered by your policy of title insurance. So it's just something that people, a lot of the time folks have it, not because they think about it and it's important to them emotionally, but because their mortgage company may require them to have it. And the mortgage company has a matching policy. It's just part of the standard closing package for almost anyone who has a financed purchase of property. And it's just like all other kinds of insurance. You do not know that you needed it until you really, really need it. In this case, because they were insured to the modern day water's edge, and he was attempting to assert that it was to the water's edge from all that time ago. That is an effort to take title to that last 2-foot beach strip of property. And lo and behold, folks from my office got retained as title counsel, paid for by the insurer to get involved. Now that case ended up going not just through our courthouse at the circuit court county level here, ended up actually going to the Michigan State Court of Appeals. We were ultimately victorious. There are particular rules in Michigan about how far back in time you can look to try and determine something when it's a dispute as to title to real property. And S's and F's type documents are not within that 40-year window that is provided by law. So we were able to succeed on that basis in both the first court and the Court of Appeals. But that's the kind of thing that would have been a monster piece of litigation, and that counterclaim to handle and deal with all of that if all those mainland property owners paid 100% out of pocket and they were able to avoid that. So if you don't know what you've got in your pocket when it comes to title insurance, you might miss that type of opportunity when you have a weird real property issue that maybe you could make somebody else's problem to defend for you.
Corinne, how long did the Party Island suit take, start to finish? What was it? 8 years, 10 years, 20 years?
Oh gosh, it wasn't. So I wasn't involved at the very beginning. I don't know when the underlying dispute started. I'm sure that the demand letters started even earlier than this. But to get all the way up the Court of Appeals, I think my period of involvement with it was, I want to say 4 years. And we came in at the tail end and were able to kind of kill it off rather quickly. It was resolved via what's in Michigan called a motion for summary disposition. So that's all of that happened. There was no going to trial. We really didn't even do discovery on it, which is the bit that's often the most time consuming and cost consuming, of depositions and getting documents and sifting through thousands and thousands of pages of stuff. We won on an initial summary motion almost pretty shortly after we got involved, but it was still years to get up through the Court of Appeals and back down. Litigation is not fast, and it is not emotionally satisfying. So it's gonna be with you a while.
That's actually a really good point. It's not emotional. You don't get any satisfaction at all with this. And even if you do get a judgment, then we, go back to our first topic, then you have to try to collect or whatever. I mean, I guess, what other things can you think of when, to use your words, you'd said, how can we future-proof ourselves as landlords? So we've got title insurance. You can help, screen your future contractors reputationally and do searches and things. What are some of the other tools you can think of for future proofing, other than hiring an attorney like yourself, which is also an option?
Sure. Well, I think the real key theme that runs through all of it is knowing what tools you have in your toolbox. Now, understanding, a great example of this is what is in your contracts. And that's whether we're talking about a contract you have with a contractor, what terms are in your lease. Do you understand those? Do you really know what they mean? Do you have a good handle? Can you tell somebody off the top of your head, what are your responsibilities under your own documents, right? And then compound that question to, if you're in a situation where you are working with a third party who has their own baseline document, what responsibilities are they putting on you? Do you understand them, and are you okay with them, right? And kind of the converse of those responsibilities, what rights have you given yourself that you're maybe not exercising? There are a lot of situations where somebody comes to me and they're like, I don't know what to do. I'm in this terrible situation. I'm like, all right, give me your documents. What are we working with? And I start reading the documents and I'm like, past you actually kind of planned for this, whether you knew it or not, whether you maybe just got this language off of a template, who knows, right? But past you may have already set you up for success. You may already have a provision to deal with exactly this question, because there's a lot of stuff in a standard legal document that you're thinking like, ugh, this looks like fluff. What is, what it's a wherefore and a jurisdiction and a venue and a yada, yada, all of those things. And, if you're working with an attorney, they're always going to be able to explain them to you and probably have 2 or 3 horror stories about times when they were glad to have had them or times when they didn't and wish they did. But a great example of something like that, that I was just talking to a client about this afternoon, is called an integration clause, right? And it's labeled an integration clause, and it looks really goofy if you just look at it in the abstract without context. Almost every contract that's, not printed on receipts will have one. And it says anything that is not within the 4 corners of this document is out. If it doesn't say it in here, even if we had some kind of prior conversation, this amends and supersedes and replaces that prior conversation, and the terms of what's in here control. That sounds kind of duh, right? The contract says what the contract says and it doesn't say anything else. Okay, congratulations. However, the reason that's relevant is because a lot of the time you'll have a reference to something, like when you're working with a contractor, you'll have an attachment that's a scope of work, right? And that scope of work, it says, the contractor hereby agrees to perform the scope of work attached here to is Exhibit A. And then you flip to Exhibit A, and either it's missing, which means, oh no, this document, because it's restricted to what actually is within the document and what's specifically referenced, doesn't actually obligate the contractor to do anything because you didn't figure out that scope of work. I see that a lot. Or what they've actually attached to the scope of work is the contractor's quote or bid on the project, which has, sure, the list of the scope of what they're actually going to do. And then underneath that has terms and conditions of their own, that by attaching it here, you have now incorporated their terms and conditions, right? So if you didn't have that integration clause for example, even if you've done a perfect scope of work that just encapsulates exactly what you want and doesn't include any bonus outside terms and conditions, it covers all the bases and doesn't have too many extras, but you didn't have an integration clause, if you had signed a bid or a quote prior, or even it doesn't have to be a physical hand signature, it can just be some kind of written acknowledgement of acceptance, right? And again, this is going to vary in the specific law in your state or province, your jurisdiction, your mileage may vary, but you can find yourself in a situation where if you're missing an integration clause, you've also accepted their terms, even if you didn't accidentally stick them into your contract. So that looks like a really boring do nothing clause, but it does have a legal impact. And it's those little bits that are most often the things that we bicker about in cases. So a lot of the stuff, it looks like it's nothing, and you look at something that you get online or a friend sends to you, and you're like, I can cut half this stuff out. This looks like nonsense. Know and understand the tools you're being given before you make that call.
Yeah, no kidding. Oh my goodness. Corinne, if a listener is interested in contacting you, how do they get a hold of you?
Oh, well, the good news is I have an incredibly Googleable name. But if you can find me on my firm's website. I'm with Madden Hauser out of Southfield in Michigan. We do have a multi-state practice. I'm physically located here, but I practice in New York, Washington, D.C., and I have colleagues who practice all over the country. So you can absolutely reach out to me through my firm's website. And I promise you, there are not a lot of Rockoff attorneys out there. And it's easy to spell.
I love it. I love it. Any last parting thoughts before we conclude?
There's always something new. That's the thing that I think I enjoy the most. Anything to do with dirt is always going to be interesting because they don't make new dirt, right? It's always going to be worth something. It's always going to be worth getting figured out in one way or another. My preference is to figure it out without litigation, but whatever manner or method you need to get it done, people are always going to have strong feelings about getting stuff figured out when it comes to real estate because it is the ultimate thing in limited supply unless you're moving on to, one of the man-made islands in Dubai or something. So it's always going to be worth the fight and worth getting figured out to get it resolved.
Oh my goodness. That's fantastic. Wow. Thank you so much for being on our show. I really appreciate your discussing a white hot topic of avoiding litigation for landlords. Super awkward topic, and but it's definitely a pain point. Knowing what's in your toolbox is really important. Thanks so much for joining us today, Corinne.
Thank you so much for having me on. It has been a delight to chat with you. Happy to do it anytime.
Thank you so much.